Good morning, everybody, and thank you for joining this Mason Hayes and Curran webinar. As always, we are delighted to have so many of you with us. My name is Claire Lord. I lead Mason Hayes and Curran's Corporate Governance and Compliance Department. I will be chairing this morning's discussion on the requirements in Ireland for the maintenance by companies, investment funds and trusts of information on their beneficial ownership, and to ensure that these details are held on a central register. These requirements have originated from the EU's 4th and 5th anti-money laundering directives, which have been designed to prevent the use of the financial system for the purposes of money laundering or terrorist financing. The requirements of these anti-money laundering directives have been implemented into Irish law through a patchwork of regulations that I will now briefly outline in order to set the scene for this morning's discussion. The requirement for certain corporate entities, including companies and investment funds, to retain information on their beneficial owners was introduced into Irish law by way of the Anti-Money Laundering Beneficial Ownership of Corporate Entities Regulations 2016. This requirement was restated and supplemented in the Anti-Money Laundering Beneficial Ownership of Corporate Entities Regulations 2019, which established the Central Register of Beneficial Ownership of Companies and Industrial and Provident Societies. These 2019 regulations also imposed an obligation on companies and industrial and provident societies to file certain information in respect of their beneficial owners on this central register. In June 2020, the registration of beneficial ownership of certain financial vehicles regulations came into effect, requiring investment funds to file their beneficial ownership information with the Registrar of Beneficial Ownership of ICAVs, credit unions and unit trusts. The EU anti-money laundering directives also require EU member states to require trustees to hold information in respect of the trust's beneficial owners. The Anti-Money Laundering Beneficial Ownership of Trusts Regulations 2019 came into force at the start of that year, introducing this requirement for express trusts. Then in April of this year, the Anti-Money Laundering Beneficial Ownership of Trusts Regulations 2021 were commenced. These regulations revoked and replaced the 2019 trust regulations. And in addition to continuing to require trustees to obtain and hold information in respect of the trust's beneficial owners, they require that certain information is filed on a central register. So the purpose of this morning's webinar is to refresh on the requirements regarding the beneficial ownership of companies and investment funds that are familiar to us, and to discuss updates in their practical application. But it's also to consider the trust regulations with which most of us are not so familiar. To do this, I'm delighted to be joined by three of my colleagues. Firstly, we have Laura Carney, who is the Director of Mason Hayes and Curran's Company Secretarial Department. And we also have Conor Durkin, who is a partner on our financial services team and who specialises in the field of investment funds and asset management. And finally, we have Nick Metcalfe, one of our corporate partners and a member of our corporate governance team. Laura, I'm going to start with you. Before we discuss the obligations imposed on companies by the regulations, can you remind us of who a beneficial owner is for the purposes of these regulations?
Certainly. Thanks, Claire, and thanks everyone for joining this morning. A beneficial owner is defined in the regulations as any natural person who owns or controls a legal entity. So that's either through direct or indirect ownership, where they have a sufficient percentage of the shares or voting rights or ownership interest in that entity. So that's in excess of 25%, or that they control it by other means. So there's also a second element of that definition where no such natural person can be identified, or if there's some doubt as to whether such a person exists, In that case, there should be entered in the register as the beneficial owners the names and details of one or more natural person who holds the position of a senior managing official in the company or society.
Thank you, Laura. So what are a company's obligations regarding its beneficial ownership?
There are two key obligations. The first one is that to identify any beneficial owners of the company in line with the criteria you just mentioned, and to hold accurate and current information on those beneficial owners in a company's internal beneficial ownership register. And then secondly, it's to arrange for the information that's held in that internal register to be filed with the central register of beneficial ownership. And then there's an ongoing obligation to keep the information both in the internal and the central register up to date. And to any update to the details should be done within 14 days of any relevant change.
Thank you, Laura. Over to you now, Conor. You will be bringing us through the application of the regulations to investment funds. But before you do, can you just clarify for us the types of entity that are included within the term investment funds?
Thanks, Claire. When we refer to investment funds, we are referring to funds that are authorised and regulated by the central bank. In particular, we're talking about 5 different types of fund vehicles, and they are the ICAV, which is the Irish Collective Asset Management Vehicle, an investment company, or PLC as we refer to it, a unit trust, which is different to the trust vehicles that Nick will be talking about, investment limited partnerships, and common contractual funds. And one of the important distinctions, I suppose, with funds is that other than PLCs, the register, the central register, is the central bank as opposed to the register for beneficial owners.
Thank you, Conor. Is the definition of beneficial owner the same in the context of investment funds?
The definition is the same as Laura has mentioned, and it means a shareholder or an investor who holds more than 25% of the shares or ownership interests in the fund vehicle. But what may be different for investment funds is the identity of the beneficial owner, and this takes into account the legal structure or type of vehicle that we're dealing with. So if you take, for example, a unit trust, again, it's the manager and the trustee who form the relationship there. And assume you don't have unit holders who hold more than 25% of the interest in the trust, then the default position is to identify the manager and indeed the senior managing officials or the directors of the manager as being beneficial owners. And similarly for investment limited partnerships, you'll have the GP and you'll have the senior managing officials of the GP. And then just to complete our understanding for ICAVs, again, assuming if you don't have, which is typically the case, a shareholder who holds more than 25%, the default position is to identify the directors of the ICAV or the PLC as being the entities who are identified for that purpose as the beneficial owners.
Thank you, Conor. And have investment funds the same obligations as companies regarding their beneficial ownership?
Yes, they do have the same obligations. And here we're referring to the 4 primary obligations on investment funds. And that is to take reasonable measures to identify the beneficial owners, to maintain an internal register of the beneficial owners, and to file details of the beneficial owners with the central bank. And lastly, and on an ongoing basis, to keep an internal register and keep that internal register and the filings with the central bank up to date.
Thank you, Conor. Nick, over to you now. Trusts are, by their very nature, they're different to corporate entities, and the regulations introduce different concepts to deal with this. Now, before we talk about the obligations themselves, could you just explain to us the types of trusts that are covered by the trust regulations?
Sure, thank you, Claire, and good morning, everybody. As you noted earlier, Claire, the 2021 regulations replaced the earlier regulations relating to trust, which were made in 2019, and in doing so, they clarified to a certain extent the type of trust covered. The 2019 regulations, as again you mentioned in the preamble, apply to express trusts whose trustees are either resident in the state or which are otherwise administered in the state. And the 2021 regulations refined this slightly by incorporating a definition of relevant trust from the Criminal Justice, Money Laundering and Terrorist Financing Act 2010, as that act has been amended. And that definition is an express trust established by deed or other declaration in writing, unless it is an exempted trust for that purpose. And those exemptions are approved occupational pension schemes, approved retirement benefit schemes, certain profit sharing or employee share ownership schemes, the haemophilia HIV trust, and as Conor has noted, unit trusts, which are the subject of separate regulations. And those types of trusts are all outside the general definition of express trust. And on top of that, the express trust in question has to have certain characteristics. And those are either that the trustees of the trustees of the trust are resident in Ireland, that the trust is otherwise administered in Ireland, or if neither of those applies, if a trustee acting in the capacity as trustee of the relevant trust has entered into a business relationship in Ireland or has acquired land in Ireland.
Thank you, Nick. And can you also clarify who is a beneficial owner for the purposes of the trust regulations?
Sure, and this is another area where the 2021 regulations have changed the scope of the 2019 regulations. And in doing that, they seem to create a bit of ambiguity, and it's worth, because of that, going into a bit of detail here. So the 2019 regulations, which no longer apply, incorporate the definition of beneficial owner for the purposes of trusts from the underlying European directives, the 4th and 5th anti-money laundering directives. And that definition identifies 5 classes of individual who can be beneficial owners of trusts. And those are the beneficiaries themselves, as you might expect, either identifiable individuals or classes of individuals, the trustee of the trust, the settlor of the trust, that is the person who largely contributes to the trust property, or the protector of the trust, which is really a more civil law concept and doesn't really apply generally to trusts established in Ireland. Or if there is somebody else who otherwise controls the trust, that person as well. And in each of those cases, in the 2019 regulations and in the directive, that beneficial owner is going to be an individual. That word is used. And the 2021 regulations, that those currently in force, retain those classes of beneficial owner, the beneficiary, the trustee, etc. But they seem to go a bit further because whilst the definition of beneficiary is limited to individuals or classes of individuals, the other types of potential beneficial owner, the trustee, the settlor, the protector, the person who otherwise controls the trust, the word individual is not specifically used in relation to those types of beneficial owner. So it is possible to read into that a beneficial owner occupying one of those classes could be a body corporate or other legal entity. And I'll come on to that in a shortly as well, because that then ties in with some further regulations which refine what beneficial, what the trustees' obligations are in obtaining information about beneficial owners. But it's worth noting as well that the definition of beneficial owner is limited where certain trusts are applied. And so for sports clubs and charitable trusts, the beneficial owners are stated to be only the trustees, the committee or the other governing body of the trust, or any other person who has control over the trust, but no other person. And for trusts which are established by wills, the beneficial owners are only the executor or the administrator of the relevant estate, or again, any other person who has control of the trust, but no other person. So that's kind of so far so good. But as I mentioned earlier, the regulations then go a bit further when we come to regulation 7, and that is the regulation which sets out the information which trustees must obtain about their beneficial owners. And that information relates really to only information which applies to individuals, such as date of birth. We'll come on to what that information is later on. And then the regulations go on to say, well, if the trustee of a relevant trust identify a body corporate who is, a legal entity, which in this context will be a body corporate, of a relevant trust, which is a beneficiary of the relevant trust. So not a trustee or a settlor, but only a beneficiary. And the trustees have to go behind that legal entity and find out information about the beneficial ownership of that legal entity. And the regulations split those types of legal entity into 2. Firstly, those who are incorporated and registered in member states and who have filed on registers of beneficial ownership of companies and bodies corporate in those member states, and those outside the EU. So taking those 2 in turn, if the trustees of a relevant trust identify that one of the beneficiaries of that trust is a company registered in Ireland, the trustees of that trust are obliged to go to the register of beneficial ownership of companies and industrial and provident societies which Laura is discussing, to find the filings made by that company, obtain that information, obtain the filing number, and that is the information they then put on the register. If the entity is incorporated outside the EU, however, if it's a body corporate incorporated in the UK or the USA, and if it is a beneficiary of a relevant trust, then the trustees are required to obtain information as respects any individuals who are constituted through that legal entity, and that's a direct quote from legislation. And that's a slightly unusual phrase in the context of Irish company law. But we can presume that it means, given the requirements I've just mentioned to obtain information about EU registered legal entities, that it's information about the people who own or control that legal entity which is registered outside the EU. But what the regulations don't do is to replicate the kind of built-in de minimis requirements that we see with bodies corporate registered in the EU. So Laura mentioned earlier that if with a company incorporated in Ireland, its directors are required to ascertain if there are any individuals who ultimately own or control 25% or more of that company, or who own or control it through other means. And that is the same broadly across Europe. However, if we have a relevant trust which has a beneficiary which is a company incorporated in the UK, and that company has, let's say, 50 individual members, then on a strict reading of the regulations, it seems that the trustee of the relevant trust would have to identify and obtain information about all 50 of those members. Whether that's the intention or not is not currently clear, but that does seem to be what the regulations say. And it's something on which clarity is currently being sought.
Thank you, Nick. I might just ask you to outline for us now the obligations that the trust regulations impose on trustees regarding the beneficial ownership of the trust, and who has the responsibility for meeting these obligations.
Yeah, so as I noticed in the slightly longer answer earlier on, the obligation falls on the trustees of the trust, and they are required to obtain certain information about the beneficial owners of the trust, which they keep on an internal register and in time file on a central register which is being established. And as with the other types of central register, there will also be obligations to update that information on the register as and when it requires to be updated.
Thank you, Nick. We might just spend a little bit of time now discussing the information that's required to be held and filed in respect of beneficial owners across the various body types. So, Laura, while a lot of us are familiar with the information that companies are required to hold and file in respect of their beneficial owners, can you just remind us of this information?
Sure. The information required to be filed with the Central Register for companies and societies is primarily in line with the information required to be held at the Internal Register also. So that's obviously the company name and number. And then in relation to each beneficial owner that has been identified, it's the full name, date of birth, residential address, nationality of the beneficial owner, as well as a statement of the nature and extent of the interest that's held or exercised, and also the date of entry as a beneficial owner or the date of cessation when it comes along to updating the register. The only other additional information that's required for filings with the Central Register, which isn't required to be kept in the Internal Register, is the PPS number for each beneficial owner. And that's required for the purpose of identifying or verifying identity, and it's not available on any RBO access search. And it's very important that the details entered for the beneficial owner match the information that's associated with the PPS number in the Department of Social Protection. And this is often where we're actually seeing filings with the RBO rejected. So, for example, where people use Irish versions of their name in the Central Register, but they may have an English version of it with the Department of Social Protection. Or, for example, people using longer versions like Jonathan instead of John, and those kind of things have led to a lot of practical issues with filing. And often, just because of GDPR considerations, you don't often get, as presenters, you don't often get the reason for why filings are rejected. So it's often not obvious why that is the case, but it's often the best starting point is to check that the information for the PPS number is consistent with what's in the Department of Social Welfare. And then obviously there's cases where there's foreign beneficial owners who may not have an Irish PPS number, and the Central Register has introduced what they're calling a Form Ben2, and that was introduced in August 2019. And that requires the details and identity of the beneficial owner to be verified by a notary public where it's been certified outside of Ireland, which would typically be the case with the foreign individual who's beneficial owner. I think we're seeing approximately about 8% of all RBO filings that are requiring a Ben2. And what we've found for a lot of companies, it's often this requirement of arranging the notarization of a Form Ben2, which has led to some difficulties in fulfilling the obligations, just in particularly over the last 18 months with the COVID pandemic has led to some issues with in-person notarizations.
Thank you, Laura. So firstly, where is the information on companies held? Who maintains the register and who has access to that information?
So the Companies Registration Office is responsible for maintaining the central register of companies and industrial society, provident societies, and they've established an online portal for arranging the filings. So all of the information is filed through this portal, and there's no hard copy or postal options for companies. So it's all done online. In terms of access, there's 2 levels of access available. So there's Tier 1 access, which is unrestricted access, and that's available to competent authorities that are set out in the regulations. And it includes organisations such as An Garda Síochána, the Financial Intelligence Unit, the Revenue Commissioners, ICAV, the Central Bank, the Department of Justice, those kind of entities, they're all set out in the regulations, and they have unrestricted access. And then separate to that, there's Tier 2 access, and that's available to any designated person under the regulations. So that's any party or firm that's required by the regulations to conduct customer due diligence. And that Tier 2 access is also available to the general public.
Thank you, Laura. Sorry, you finished. Yeah, sorry. Thank you, Laura. I wasn't sure if you were finished.
Okay.
Conor, I'm just in terms of the information and holding requirements for investment funds, are they the same as for companies?
Yes, investment funds are required to supply the same information. We're talking about the name, residential address, date of birth, and nationality of the beneficial owners, the nature and extent of the interest held in the fund. One important distinction, however, is to be made is that to date, investment funds have not been required to file details regarding the PPSs of the beneficial owners with the central bank. However, during the final quarter of this year, 2021, there will be a new filing requirement, which will require PPSs of each beneficial owner to be filed with the central bank. And I'll mention that further when we discuss recent developments later on in our discussion today.
Thank you, Conor. So you've mentioned that the central bank maintains the register, and who has access to this register? The central register.
Again, it's the same access rights that Laura had mentioned. We're talking about full access rights, shall we say, to public authorities being the Gardaí, Revenue Commissioners, the Criminal Assets Bureau. They have unrestricted access. However, the general public also have access to, as Laura described, Tier 2 restricted access. And this is to the same level of information that we're talking about, details of the identity of the beneficial owners, not their residential addresses, but details as to their nationality. But what is different, I suppose, is the manner in which details of the beneficial owners can be obtained. The beneficial ownership details can be obtained by sending an email request to a dedicated email that the central bank operates. And there's no charge for the search request either. So it's very much a streamlined process for obtaining details of beneficial owners.
Thank you, Conor. Back to you now, Nick, and trusts. What information are trustees required to hold in respect of the beneficial ownership of the trust itself?
It's the same information as Laura and Conor have identified there: the name, residential address, nationality, as well as nature and extent of interest held by the beneficial owner. And again, there is a requirement for the trustees to obtain the PPS number of each beneficial owner. Or in the case of trusts, where the beneficial owner does not have a PPS number and is not resident in the state, another unique identifying number and a copy of the document from which that number is derived, and the regulations used as examples, passports or national identity card.
Thanks, Nick. So while the obligation to maintain internal registers of beneficial ownership of trusts has been in place for a little while, the central register is new. Who's going to maintain it? When will it open for filing? And what deadlines do we all need to be aware of?
So the central register is in fact being maintained by the Revenue, and the register is already open for filing, and that's done by the ROS system, the ROS system. And we understand as well from some contact we've had with the Revenue that the filings are being made. The good news for people listening maybe is that filings don't have to be made yet. The regulations came into effect on the 23rd of April of this year and provide that for all relevant trusts established at the time of when the regulations came into effect, then the filing deadline is 6 months. So that will be the 23rd of October of this year. For relevant trusts established after the 23rd of April, the filing deadline is 6 months from the date of establishment.
Who's going to have access to this information, Nick?
So again, consistently with the other two types of register already set up, there are two categories of access. There's unrestricted access and there's restricted access. And again, unrestricted access is open to those bodies of the state who are charged with combating money laundering and terrorist financing offences. So again, with regards to the FIU, the Revenue itself, the CAB, etc. And again, it's certainly in common with the company's regulations, and I presume as well the financial institution regulations. There is a safeguard there in that any access must be made by a person within the relevant organisation of a certain rank, and that application must have been approved by a person of a higher rank. So there are safeguards, presumably against abuse. And in addition to the state bodies mentioned, there are noted competent authorities within the trust regulations, and those are again Central Bank, Ministry of Justice, Law Society, and so forth. Again, whose employees of a certain rank have rights of unrestricted access. And unrestricted access is everything which is on the register, but not the PPS or other unique identifying number, which again, Laura mentioned the purpose for that. It's to enable the registrar to identify, that's why I said ascertain the identity of the beneficial owner whose details have been filed. And the state bodies mentioned are entitled to share the information which they gather from the central register with their equivalent bodies in other member states of the European Union. So that's unrestricted access. There are also types of classes of people who are entitled to restricted access. And again, as with the other two types of register, the restricted access is name, month and year of birth, but not full date of birth, country of residence, but not residential address, nationality, and again, the statement of the nature and extent of the interest or control exercised over the trust property. And the people who are entitled to restricted access are, again, designated persons, which is in keeping with the other ones, but those, again, are persons who are obliged to conduct know your client and anti-money laundering exercise in relation to their clients when entering into business relationships with them. Law firms, banks, the obvious examples. And also other people, which loosely could be categorized in the general public, save that category of person is significantly limited by the trust regulations. Whereas, as both Laura and Conor have mentioned, there is a kind of general access to the register for the public. With the trusts, that isn't the case. And any person other than those categories which I've mentioned who wish to have restricted access to the information on the central register of trusts must demonstrate to the registrar that those persons have a legitimate interest in that information. And that legitimate interest is that the applicant must demonstrate to the registrar that he or she is engaged in the prevention, detection, or investigation of money laundering or terrorist financing offences, that he or she wants the information in question for the purposes of that protection, detection, investigation. So it's not just a fishing expedition, it's for the purposes of some ongoing action that the person is taking. And that the trust is connected with persons convicted of money laundering or terrorist financing, or that the trust holds assets in a higher risk country. And alternatively to that, a person other than those mentioned, designated person, state body, etc., may request restricted information if it can be demonstrated that the trust in question holds a controlling interest in any entity which is incorporated outside of the EU. And the regulations anticipate that in either event, the applicant will make written submissions to the registrar explaining what their legitimate interest is. And the registrar has the discretion within the regulations to say yes or no on receipt of that, of those written submissions. And just for completeness as well, there are further safeguards relating to information on beneficial owners who are minors.
Great, thank you, Nick. You've set out the information trustees are required to hold. I think I skipped over the question. Is there any distinction between that and what actually gets filed in the central register? No.
Again, it's the same as with the other registers. The trustees are obliged to file the information on the internal register and the PPS or other unique identifying number for the beneficial owners. Although again, those numbers, whichever type they are, will not go onto the register itself. And as I've mentioned, are not available for anyone to get, even those with unrestricted access.
I'm going to move on now briefly just to compliance and consequences of not filing. So I'll put a question to each of you, and Laura, you can start. Could you outline for us the consequences of a company not complying with its filing obligations?
Yeah, so where a company has failed to deliver the beneficial ownership details to the central register before the statutory deadline, I mean, initially for companies that were in existence at the time, this was November 2019, and then going forward, it's within 5 months of incorporation for any new company. So any company that fails to meet those deadlines commits an offence, and they are liable on summary conviction to a Class A fine. So that's a fine of up to €5,000, or on conviction on indictment to a fine not exceeding €500,000. And again, there's similar penalties set out in the regulations for providing false or misleading information to the central register.
Thank you, Laura. Same question for you, Conor.
That's correct. So rather than repeating what Laura has said, investment funds are subject to the same requirements. But perhaps a differentiating factor here might be just to identify to whom the regulations apply to. They apply to the investment fund, but in the context of, let's say, unit trust or investment limited partnership, it should be clear that it applies to the managing body of that vehicle. So that will be to the GP in the case of, or general partner in the case of a partnership, or the manager in the case of unit trust. Therefore, the managing body and the board of that body should be aware of changes that are made to the fund's investor base. And often, because there will be some distance removed from that, I think it's incumbent upon the boards of managers and ICAVs or otherwise to ensure that there's appropriate level of monitoring of the shareholder base being carried out, whether that be carried out by the AIFM itself or most likely, in most cases, the administrators. I think that's an important practical consideration to be brought in that context.
Thank you, Conor. And same question for you, Nick, in respect of trusts.
Yeah, well, maybe to everyone's relief, given the length of my answer so far, the penalties in the trust regulations, to a large extent, mirror those in the company's regulations that Laura outlined earlier.
Thank you, Nick. Laura, when it comes to companies, it's a lot easier to measure compliance. We've also had time to get used to the existence of the RBO. What has your experience been in terms of compliance by companies?
Generally speaking, compliance levels have been reasonably good for companies. Up to the end of 2020, 81% of all registered companies and 64% of industrial and provident societies had made filings with the central register. Of course, this only reflects compliance with the initial filing obligation, and it doesn't really give any indication of the level of compliance with the obligation to keep the information up to date. That's obviously going to be something that's more difficult to measure. Anecdotally, it did appear that companies that were in existence at the time of the initial filing deadlines in 2019 were relatively compliant, and there was a major project of raising awareness around the requirements at the time. However, levels of compliance for newly incorporated companies since that date do seem to have been somewhat lower. Our own experience from our own client base is that generally speaking, there isn't a major resistance to the transparency of ownership element of the implementation of the regulations. Any difficulties we've had around fulfilling obligations within the deadlines have typically been in the area of completion and notarizing of Form Ben 2s in various jurisdictions. In particular, I suppose it has just coincided with COVID restrictions around the world in the last 18 months. So that has often been where some of the possible delays in compliance have come from.
Thanks, Laura. Conor, investment funds haven't had as much time. So the deadline was actually Christmas Day last year, which is a great date really for a deadline. Has your experience with investment funds been the same?
It has, if anything, the experience would illustrate almost full or essentially full compliance with the filing requirements. It is correct to note that we don't have that much experience, shall we say, in relation to ILPs or common contractual funds, because the central register has only been operational since the 1st of September, so that's not long at all. But when we look at the list, so the central bank has published a list of funds where it identifies those funds that it maintains a central registrar, and that's very, very comprehensive. From looking at that, I'm not aware of any gaps in that, but in addition to that, our experience would illustrate as well that there has been full compliance in relation to the filing requirements with the central bank so far.
And how do you anticipate the central bank is going to deal with defaulters?
Indeed, the central bank has been monitoring compliance in this area. So during the first quarter of this year, it sent out a reminder in the context of funds that might have been terminating or otherwise. So it's an area that the central bank is actively policing. In terms of the general enforcement approach that the central bank takes, people who operate in the funds industry will be familiar that the central bank operates an active risk-based approach to supervision, and that is very much supported by the credible threat of enforcement. So taking that philosophy to bear into how it monitors compliance generally, we would expect that enforcement in relation to beneficial ownership filings would be no different, and that this is an area that the central bank will actively monitor and indeed enforce.
Laura, what do you think the future holds in terms of enforcement action being brought against defaulting companies?
The central register, I suppose they scheduled what they called a staggered non-compliance reminder campaign in March 2020 for all entities who hadn't filed by the initial deadline of the 22nd of November in 2019. Obviously, with the outbreak of the COVID-19 pandemic in or around the same time, the campaign was postponed and they only recommenced that in late 2020, and it's continuing into 2021. So a lot of companies will have received non-compliance reminders, and they've also followed up then with slightly more strongly worded 14-day reminder letters, which have issued to companies and to the individual directors of the companies themselves. We're not yet aware of any prosecutions that have been instigated as yet for non-compliance, but you'd have to think that it's only a matter of time before we get to that stage of enforcement.
Thank you, Laura. Before we move on to questions and answers, I might just put it to the panelists to maybe give us some tips in terms of recent update, and in Nick's case, perhaps where do you foresee practical challenges with the rollout of the filing requirements in respect of trusts?
Well, I mean, that's not quite an answer to the question, but just to continue the theme of enforcement there, I think it's worth noting in relation to the trust register, because it's operated by the revenue, the revenue, of course, has inbuilt and fairly active enforcement section and culture itself. So it's probably worth working on the basis that if you don't fulfill your obligations as a trustee of a relevant trust, you may receive reminders and then action maybe quicker than the other registrars have put in place, although that's speculation at this point. But just generally, as I noted earlier on, the new regulations, which haven't been in force all that long, did or do seem to have changed the type of beneficial owner that the trustees need to go after. Certainly in the context, as I discussed earlier, of trusts which have beneficiaries which are bodies, corporates incorporated outside the EU, there may be a fair amount of work to ascertain who the individuals who own or control those entities are, and that even if there are a number of them, that it may be necessary to obtain details on all of those beneficial owners. So trustees need to be aware that, practically speaking, that there may be a fair amount of work for them to obtain the necessary information to get it filed on the internal register, and then to make the filings by the first deadline of the 23rd of October So that I would expect to be the main practical consideration here, just the information that's necessary to obtain and the time that there is to file.
Thank you, Nick. Laura, I suppose a slightly different question for you. Have there been any recent developments in relation to the Central Register of Beneficial Ownership that you'd like to mention?
Yes, I suppose the most relevant one is the Criminal Justice Money Laundering and Terrorist Financing Amendment Act in 2021, which came into effect in April this year. And while the Act hasn't changed the obligations for companies, its implementation has brought in changes around the obligations of designated persons. And this has led to compliance with the regulations being a much higher priority, in particular for newly incorporated companies. Just as a reminder, designated person is defined in the 2020 Criminal Justice Act, and it includes financial institutions, accountants, auditors, tax advisors, legal professionals, as well as dealers in high wealth goods and that kind of thing. And this 2021 Act requires that prior to the establishment of a business relationship with a customer, which is a company or society, the designated person is obliged to check that information concerning the beneficial ownership of the customer is entered in the RBO, and that information is consistent with the information that has been provided by the company as part of the designated person's due diligence process. And there's also new forms introduced by the Central Register for designated persons to report any non-compliance or discrepancies in this information. And in practice, certainly banks, which are credit institutions or financial institutions, in theory, they can allow an account to be opened by a customer before ascertaining the beneficial ownership, as long as no transactions are carried out on behalf of the customer before getting this information. So in practice, banks are insisting that RBO filings are made prior to a bank account being opened. And this means that from a practical perspective, newly incorporated companies who want to commence trading and open a bank account really need to ensure that their filings are made with the RBO as a matter of urgency post-incorporation, rather than waiting the 5 months which they're actually allowed under the regulations. And the 2021 regulations, they also oblige designated persons to report any non-compliance or discrepancies that they find in the information that comes to their knowledge from other sources when they're carrying out due diligence. So it has become much more of a priority for companies where they're being requested this information from banks when they're opening bank accounts, and also from other service providers such as auditors when they're establishing a business relationship.
Great, thank you, Laura. Same question for you, Conor. Any recent updates?
Thanks. There have been recent significant developments in this area. Amending regulations were published in July 2021, which require the PPS numbers of beneficial owners to be submitted to the central bank. And the central bank clarified in a letter to industry on the 19th of August that it will require a resubmission of beneficial ownership details by all relevant entities, and that information should include the PPS numbers of the beneficial owners, the CBI or central bank reference number to non-PPS owners where they have issued one, and there'll also be changes to questions in relation to whether or not the individuals hold PCF positions with the central bank. The central bank has clarified that it will implement a process to deal with beneficial owners who don't have a PPS number. There'll be quite a few of those, and here we're really referring to foreign nationals who wouldn't have a PPS number. At this stage, it's not clear exactly what type of process the central bank will put in place. However, looking at the experience of the CRO, we would expect that it would be a very similar process. You're going to have a form of BEN2 or an equivalent document used as a means of capturing and validating the information of people who don't have a PPS number, mainly individuals who are not resident in Ireland. That's a significant change. The filing requirement for that will be implemented during the fourth quarter of this year, and the deadline, I think, is the 1st of January 2022.
Great, thank you, Conor. I think we'll go to some Q&A now. They're coming in hard and fast, as I'm sure our panelists will be delighted to hear. So what I'm going to do in the time available just before our close is I'll try and scan through them and pick out the questions where we haven't already provided an answer, and then hopefully we can get to the remaining ones as time permits. One actually I don't believe that we did touch on, Nick, is in relation to actually collecting the necessary information, how is a trustee expected to do that?
So the regulations contain very similar provisions from some of the company's regulations with regard to assisting the trustees in getting their information. And so the trustees are obliged, if they don't know who the beneficial owners of their trust is, to send notice either to the people who they think are the beneficial owners, or if they don't have that level of information, to people who they believe may have that information. And there are obligations on the recipients of those notices to respond with the information within a certain time period. So the regulations give, to a large extent, the trustees the kind of power to obtain that information under punishment, under penalty of punishment under the regulations.
Thank you, Nick. I suppose another more general one is actually about Ireland's compliance, and it's one for you, Laura. How does Ireland approach to the implementation of all of these EU directives compare to other EU countries?
I've had a look at this recently. So there was a deadline for all EU countries to establish a central register by January 2020. Most EU countries have done this, I think, up to a couple of months ago. There's about 3 that haven't. And they've done it, like, typically, I mean, the directive is fairly prescriptive in terms of the information that must be provided. So there's fair consistency across registers in that sense. Where I gather there is some differences is that in terms of the access to the register. So several countries have established registers that don't have public access, and then others similar to Ireland have established registers that have a paywall for access to information, or some have access that's only available to nationals and that kind of thing. So other countries have established a register with free public availability, and there's been some criticism across the board, obviously, from a transparency perspective, where paywalls have been put in place or where there's limits on the availability of access to the public. Obviously, given the plan that there is to ultimately establish interconnectivity of registers across the EU, I think it's likely that there'll be a push for uniformity of access to information across EU countries over the coming years.
Thanks, Laura. And now just to spread it around, Conor, I get quite a general question. The steps an ICAV needs to take in order to comply with the requirement to file details with the central bank. Do you want to expand on that?
An ICAV should ensure that there's appropriate reporting to it. Again, the board of the ICAV will be some distance removed, maybe in terms of what's actually happening at the shareholder level, and therefore reporting from the administrator or from the AIFM should be put in place, and that should be a form of regular reporting to ensure that if any updates are required, that they can be filed with the central bank on a timely basis. And again, don't assume that somebody's doing it. It'll be important to identify either the company secretary or possibly the AIFM if they're going to undertake that responsibility to make those filings with the central bank within the time frame required. So it's very much put in place a program to ensure compliance.
Great, thank you, Conor. Nick, we have a question here in relation to Section 7 of the trust regulations. So, in terms of the exception from the requirement to hold information on the beneficial owner when a legal entity that is a beneficiary of the relevant trust has already filed their particulars in the central register. So, do you want to expand on that or answer the question?
Yeah, sure. So as I mentioned earlier, that where the trustees of a relevant trust identify that one or other of their beneficiaries is a legal entity, so a body corporate or similar, incorporated in an EU member state, that there is a requirement to go to the relevant register of beneficial ownership of the relevant type of entity in that member state and see what has been filed. And there is an obligation to get the information from that register, and that information is the name and registered address of the legal entity in question, and a statement of the nature and extent of the interest held, or the nature and extent of the control exercised by that legal entity, and any filing number that may have been generated by the relevant register. I'm not sure off the top of my head, maybe Laura could confirm whether the central register for the ownership of companies generates a filing number. If it does, you get it. If it doesn't, you don't need to get one. But if, say, the equivalent register in Germany or Italy or wherever does generate it, then you need to get that filing number. And then the obligation is to put that information onto the internal register and subsequently file that information in the central register.
Great, thank you, Nick. Conor, I've one for you now. I'll read it out. So for client KYC, prior to establishing the business relationship, FSPs should check that filing has been completed on the central register for ICAV credit unions, unit trusts and corporate entities. There's no reference to ILPs and CCF. So where the client is an ILP or CCF, do firms need to check if the general partner or management companies have made filings on behalf of the funds?
Thanks, Claire. It's a very technical question. We talked earlier about a patchwork of regulation, I suppose, and this to my mind kind of illustrates that. On the one hand, we've the regulations that are introduced by a statutory instrument that apply to ICAVs. The code for ILPs and CCFs is contained in the Investment Limited Partnership Act, and therefore it imposes the same responsibilities. But to get a more comprehensive picture in relation to this, you also have that section of the recently amended AML legislation, which talks about obligations on designated persons generally. So what does this mean? You put the pieces together. To my mind, it means that you do have a requirement if you're a designated person interacting with a CCF or ILP, and therefore you should check the beneficial register. You're given access or the right to access through the provisions in the ILP Amendment Act. So in a sense, or maybe a shorter way to say it, ILPs and CCFs and the responsibilities for designated persons interacting with those entities is the same as that which would apply if you were interacting and looking for details of an ICAV.
Great, thank you, Conor. No, thanks, perfect. Laura, I have one for you on the Ben 2 form. Where it's signed outside of Ireland in front of a notary, does it need to be apostilled for legalisation purposes before being uploaded to the RBO?
That's a nice easy one. The straight answer is no. No, it doesn't. The central register doesn't require apostilling which is actually great. It makes it slightly easier. In practice, they will also accept forms that have been sworn by practicing solicitors who are authorised to swear declarations in the jurisdiction in question, even though the form itself specifies that it must be a notary. In our experience, they do actually accept them from practicing solicitors from most jurisdictions.
Great, thank you, Laura. Just scanning down here, Nick, I have one for you. What percentage of ownership of an entity or a body corporate is the trustee obliged to report for non-EU beneficiaries? So essentially, I'll let you clarify what you said there in terms of reporting all beneficiaries, irrespective of percentage. But I'll hand over to you to.
No, sure. Thanks, and that's a very good question, because as I hope I kind of came across with earlier on, that the legislation isn't maybe as clear as we would have hoped. So just to step back slightly and maybe repeat myself from the answer to the previous question I responded to. The regulations require trustees, relevant trusts, to take further steps where the beneficiaries of those trusts are legal entities. So again, bodies, corporate, that kind of thing. And those steps depend upon whether the legal entity is incorporated and registered in an EU state and has made filings in that state or not. And I discussed in the response to the previous question I answered what needs to happen where the legal entity in question is registered in the EU and has made the filings, and I think we've dealt with that. The second category is where the legal entity is not incorporated in the EU. It's not made any filings or anything like that. And so, again, we can use the examples of a UK or the US incorporated company, which is the beneficiary of a relevant trust. And what the regulations require there is that the trustees obtain the necessary information. So we know what that information is, well, the name, the address, the date of birth, etc., of the individuals. And again, I'll quote from the the regulations, because it's not a commonly used phrase, but those individuals who are constituted through that legal entity. Now, on a kind of strict reading of that, you'd have to assume that these are the people, the individuals who ultimately own or control that entity. But whereas built into the other type of legal entity is this 25% threshold, because you have to meet that threshold to go on the register, or put the senior managing officials down. That isn't specified here. So looking at it strictly, you'd have to say, well, you go behind it, you find out everybody there. Now, maybe that isn't what is intended. Maybe it is intended that really we'd only look at the 25% ownership and then move on to senior managing officials, but it isn't specified there. And so you may be on the side of caution and go for the more onerous route. Now, it is worth noting at this point that there is some dialogue open between members of the profession and the Revenue and Department of Finance. And it may be that these questions are answered and can be or we can get a more clear answer. But right now, because the register isn't really yet up and running, and certainly not with full steam ahead, it's not possible to answer that question yet. I guess I will point out as well that the Revenue have put up some FAQs on their website, which they have said will be updated. So it isn't there. I looked at the FAQs this morning. That question isn't specifically answered there yet, but it may be in the fullness of time. So I guess my answer is we don't know, but erring on the side of caution, you would read that to say that no percentage applies.
Thank you, Nick. We're actually coming up to time, and in order to release you as we promised we would do by 12, I want to hand back to our panelists just to give us their takeaway. So what do they recommend you do today in terms of going away from the webinar? And I'll start with you, Laura, please.
Sure. Was the key takeaway for companies, particularly in the run-up to a busy compliance season, is for advisors and companies to double check that their RBO filings are up to date and that any changes in beneficial ownership have been reflected in the registers. And that's particularly in the cases where senior managing officials may have been entered and there may have been board changes or that kind of thing in the period since they were first filed, to make sure that everything's up to date. So obviously with designated persons now obliged to check these details and report on discrepancies when commencing relationships, and the RBO also instigating a more vigorous enforcement practice, it's going to be a key ongoing compliance obligation for companies rather than a one-off. So they need to just keep focusing on it.
Thank you, Laura. And Conor, what would you suggest?
Very briefly, for me, the key takeaway is that funds should be aware that they will need to resubmit details, including details of beneficial owners, with the central bank by the end of this year. To watch this space, central bank is going to identify that process for obtaining details in relation to foreign nationals. And of course, don't assume that things are put in place. Double check to ensure that there's a monitoring process. That should be relatively straightforward, given the fact that funds tend to fall in two ends of the spectrum, one where you have a broad shareholder base, not likely to have any one investor tipping over the 25% limit, and the other end of the spectrum where you've got effectively private investment vehicles where the shareholder base is fairly static, but just ensure that there's a compliance monitoring program in place for those funds.
Thank you, Conor. And I'll leave it with you, Nick, to have the final word. A lot happening in respect of beneficial ownership of trusts.
Yeah, and I'll be repeating myself slightly, but the takeaways, I think, with the trustees to make sure that they are aware of their obligations and to get themselves ready for filing with the deadline a little more than a month away. And secondly, and this kind of follows on from the previous answer I was given to the question, maybe keep an eye out for advice as it's given to clarify what those obligations are. And again, the Revenue are running an FAQ section on their website, which is worth checking.
Great, thank you, Nick. And thank you once again to the panelists for their great interaction today and all of the very helpful information. And thank you to all of you for joining.